So in this second part of the lecture on an introduction to legal drafting, we'll have a look at the use of precedents in legal drafting. So first of all, just to explain what the idea of a precedent is, very simply, it's just a template which can be used as a basis for your draft. So whatever the document is you are seeking to draft, it's useful to have a starting point, and often similar types of documents have been drafted in the past. There'll usually be differences, and that's one of the really important things to stress, and we'll come to that in a moment, but it's very helpful, saves time and cost if you've got something to start from, and what we call those templates are precedents. The quote on the slide, that precedents are a good servant but a poor master, is a really important point to take on board. One very easy thing to do when you're drafting is to find a precedent and then stick to the precedent rather than thinking clearly about what it is that your document needs to do and the instructions of the client and what your client wants to achieve. So you've got to very firmly identify what your instructions are and what the goals of your client are, and highlight and make clear to yourself exactly what the key aspects of your document needs to do. So be very clear at the outset what your document seeks to achieve. Then you can find a precedent to try and help with that. And usually it may well be a combination of precedents. So there might be an example of an agreement about, say, paddling down a canoe, so getting access to a river, and also one about parking, which you can then conjoin and take the best bits of both to create an agreement that deals with both, which is what your client wants to achieve. And we'll have a look at that scenario for canoeing and access to a river and parking in your first drafting exercise. Precedents generally come in two forms. So there's usually what are called whole precedents, which provide a whole agreement or a whole transfer or a whole will, and then there are precedent clauses, so that deal with particular aspects which you may wish to include. So it does two jobs. It provides you some security and a starting point from which to start your drafting, and it also is useful for thinking about what other issues might come up. So it may be that you've got an idea of what your document wants to achieve, but the consequential effects, other things that you need to think about which other people would have thought about in the past, you may not have done. So the precedent will give you some insight and inspiration for what clauses are appropriate to best deal and protect your client's position. So perhaps the best way to give an example of a precedent and actually to have a look at it and think about it in more detail is to actually have a look at it. So that's what we'll do. If I just come out of the PowerPoint slides, and I will flick to the internet, we'll see that we are on Moodle, on the Lawyer Skills Moodle site. So I've uploaded onto the Lawyer Skills Moodle site a couple of precedents that will be useful for getting you started when we do your first draft exercise. So I'm going to click on the first one, License for Canoeing and Paddle Sports. And this is just an example of a precedent, really, for our purposes of talking about what precedents are. So what we'll see here is that there is an example agreement between somebody who is the owner of some land, which will be part of which will be abutting a river, and a licensee who wishes to use the river. So this basically sets out an agreement which presumably has been used in the past between two parties where just this situation has arisen. First of all, just to emphasize the way that the precedent works, so you'll see that there is various blanks, brackets, and square brackets here, for example, that basically prompt you to fill in the information that you need given your instructions. But it's really important to emphasize it's not just a filling in process. It is a process of thinking about what you need to achieve and using this as some help towards that. But you obviously very clearly need to think about what it is that you need to achieve with your document, rather than just slavishly amending the precedent and just filling in the blanks, if you like. But just to emphasize, so here, for example, we've obviously got, this is a draft agreement, so we've got some blanks here to filling in the date, which will be done once the agreement is actually executed. We've got some round brackets here, which basically requires you to fill in the information about who is the owner of the land and their address, which we obviously need to do very carefully. And coming down, we have got spaces here, square brackets, where you may need to think about, they're usually prompting you whether or not you need to include that depending on what your instructions are and what the goals of your document are. So it may be that you need to include these things in the square brackets and actually get rid of the brackets themselves, or it may be you delete the whole thing. So you'll also find that in some precedents there will be footnotes, so there'll be little notes here. So I'll just scroll up and you'll see the previous example here, where it relates to commentary or perhaps sometimes suggestions about the relevance of particular legal provisions or perhaps other precedents that might be relevant. So a second thing is to think about a precedent as also providing a general overview of how to format the document. So in a typical contractual agreement, this is not an untypical way of setting it out. So at the start we've got the parties, and also the identification of effectively what type of contractual agreement this is. This is a license to essentially access a river, so it's headed the license. We've then got, which is very common, a definition section. So definitions are very important in drafting, and it's as good a way to introduce you to them as any by looking at a precedent. So these are terms which essentially are used a number of times within the document, and by having a precise definition of what they are, it basically makes the rest of the drafting easier. Now the way that you come up with them, if you are creating them yourselves, is generally when you are writing the operative clauses of the agreement, which we'll come to in a moment, you will find that you are continually referring to these things. So, for example, obviously if we're trying to identify where on the river that you have access on a particular person's land, then you may well want to refer to a plan. Rather than referring to a plan and trying to describe it, a sensible way is to say, right, well, the access points as identified on the plan, and then you give the plan a definition, which means the plan attached to this document. And if you have more than one, you might have plan 1, plan 2, plan 3, etc. And again, rather than writing the river, whatever the name of the river is, then it's perhaps best just to say the river. The canoeing rights, so there might be a number of different rights which you're effectively giving, and rather than having to refer to them all, you can just refer to them as one and then set them out elsewhere in the document and give them a definition. So definitions are really, really useful tools for making your drafting simpler and easier. However, it does come with some slight warnings. It's very easy to use a definition and then misuse it, so you don't stick to the definition that you've given it. And it's also very easy to effectively forget that you're using a definition and not use it properly. So one thing in particular to be important of is if you have defined a term, the way that we normally do it is to give it a capital. So you'll see here the plan is with a capital P. Now wherever that appears in the rest of the document, and we'll just scroll down and we should find it. I've chosen the wrong one to choose there. Perhaps we'll just choose another word. The plan is referred to somewhere there. The river, for example. So you'll see here that the river is referred to here, and there's a capital R and a capital R. So that means that we know when we're talking about the river, we can go back to looking at the definitions here to make it clear on what we're talking about. But it's really important that you remember to use the capital if you're using a defined term, and also to remember that if you have defined the term, to make sure you're consistent in using it. So don't start describing it as something else. Just a very quick overview of the rest of the document. So normally the format in contractual agreements is to start with definitions, then move on to what I would term the operative parts of the agreement. So here the actual detail of what the license is going to do. And also, as we scroll down the page, the particular obligations and rights created. So we'll see in that first part we've got reference to the rights of the licensee, and then we've also got a section on the obligations of the licensee and also the obligations of the owners, and that's not untypical. So it's setting out the primary obligations and the primary rights that are created, and that is usually the first part of the document. Quite often, and it's a very short precedent, but there's then what might be termed more general terms, so terms that are common and necessary in these sorts of agreements. So in more complex agreements, it might be things like the jurisdiction under which any disputes are resolved. It might be excluding any third-party right, and it could be any number of sort of clauses that might be relevant in the particular context. Other point about about this particular precedent is it does use schedules, so it sets out the obligations in a schedule. It's not, you don't have to use schedules, and generally the longer the document, the more merit there is in using them, but it puts everything sort of at the back of the document. So the actual primary obligations and if you like, the primary operative clauses are kept very simple, and the detail is put away in the schedule. So schedules are a useful tool, particularly if you've got a fairly lengthy document or you're wanting to detail a number of different rights and obligations. Okay, so we'll just go back to the PowerPoint slide now, just to finish this off. So, precedents, just to conclude, precedents are very useful for us for drafting legal documents. But as I say, the key point is not to get carried away with the precedent. So the precedent is only as good as it was when it was first drafted. It won't automatically fit the situation you've got. And also, the precedents may not be that good. So there is a case that you'll study when you do equity, for example, called Regal-Benkian settlement trusts. And part of the reason that went through to litigation was because of the poor drafting of the trust deed. One of the comments by, I think it was Lord Reed, was that he was rather surprised to find that the actual wording of the clause that was used in that particular case, which caused part of the problem, was actually being used as a precedent in a professional legal encyclopedia of forms and precedents type text. And then other people were obviously copying it, and that without thinking about the actual merit of the precedent itself. So just because there is a template doesn't mean you can't make it better for your own situation and better in general. So treat it with caution, but do make use of them because they are helpful. Now, in terms of where to find additional precedents, then we do have a collection of hard copy precedents in the form of the Encyclopedia of Forms and Precedents, which was created and edited by Lord Millett, I think, initially. And they are available in the library. I will hopefully show you where those are once we have our first small group session. But be aware of them, and you may find them useful both in terms of your assessment and in the future.